Welcome back. Hope everybody had a pleasant, productive couple of constituency weeks. Welcome to meeting number 23 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of February 2nd, 2026, the committee is meeting to resume its study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters, child protection, gender-based violence, delays, and other measures. Today's meeting is taking place in hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. For Mr. Housefather and Liz Latanzio, sound tests were done. Just nod if you can hear me. Patricia, Ms. Latanzio, your sound test was done?
It was not, Mr. Chair. I'm waiting.
Okay. All right. Maybe you can do that while I carry on with the opening remarks.
Sure.
Or not. Okay.
Sure.
And then let us know if there's a problem, or somebody let us know if there's a problem. I will dispense with the rest of the online instructions as we know them well. Please wait until I recognize you before speaking. For those participating by video conference, you know the drill. For those on Zoom, you have all of the instructions on your screen. Which takes me to welcome to our witnesses. We have, in our first hour, we have from the National Association of Women in the Law, Suzanne Zakour, the Director of Legal Affairs. Welcome. And from the Regroupement de Maisons pour Femmes Victimes de Violence Conjugale, we have Karen Barrett, lawyer and project manager, and Louise Randu, co-lead political affairs. Thank you very much for joining us today. We're grateful for you taking the time. So each organization will have up to, remind me of, 5 minutes to make your opening remarks, and then we'll open the floor to questions. So, Ms. Zakour, since you're to my left, perhaps we'll start with you.
Thank you, Mr. Chair. The National Association of Women in the Law, or NAL, is an award-winning organization that advances women's rights through feminist law reform advocacy. The focus of our brief is technical amendments to improve Bill C-16, which I'll group under 3 themes. First is where the bill may backfire against survivors. If they're not amended, new provisions on coercive control, mandatory minimums, and constructive first-degree murder, which is labeled as femicide, will have adverse consequences on survivors of gender-based violence. I'll focus, since I have very limited time, on coercive control. This offense would cover controlling or attempting to control the manner in which the intimate partner cares for children. That's paragraph 2CII. This subsection needs to be removed. Family courts, we've seen, have already started labeling survivors of domestic violence as engaging in coercive control because their attempts to keep themselves and their children safe are seen as controlling or alienating. So if this paragraph is not removed from the offense, abusers will exploit it to threaten survivors with criminalization, and that will make it more difficult to leave an abusive situation. My second theme is positive developments, but with some arbitrary restrictions. One example is the criminal harassment offense. Under the reformed offense, it will be illegal to willingly cause fear to your intimate partner, among others, if a reasonable person would have been afraid, but not if your partner was actually, in fact, afraid. When abusers cause fear to their partners or ex-partners, really it's irrelevant whether an imagined reasonable victim would have been afraid, since the abuser is specifically targeting the fears and vulnerabilities of a person they know very well. So NAL urges the committee to define harassing conduct as the one that either causes subjective fear or would reasonably be expected to cause fear. As long as the accused willingly cause fear, it does not matter if the victim's fears and phobias are reasonable, as it's not the victim who is on trial. Further, the bill recognizes that abusers use violence against animals to control and terrorize victims, which is a positive development, but then draws an arbitrary distinction based on the ownership relationship with the animal. So again, in criminal harassment, saying, "I will kill your dog," is threatening conduct, but saying, "I will kill your mother's dog," is not. Where threats to animals are recognized, which is in criminal harassment and coercive control, we recommend changing the language of "an animal that is in the care or property of the victim" to "any animal known to them." NAL also supports various measures in the bill that are procedural protections for victims of intimate partner violence, but not limiting them to cases of serious offenses involving physical violence and threats, which is a little bit ironic in a bill that seeks to recognize coercive control. So throughout the bill, there are many places where there are protection measures that are called for in cases of an indictable offense in the commission of which violence was used, threatened, or attempted against an intimate partner. And we recommend replacing this language throughout with "any offense committed against an intimate partner." Now, the bill also seeks to increase protections against the use of victims' therapeutic records, but without applying the same protections to other records that can also be highly sensitive and very private, such as child protection records, personal diaries, and sexual assault centers records. All personal records should be treated with the same care, such that they're only produced in criminal trials when they contain evidence that can raise a reasonable doubt as to the guilt of the accused. Third and lastly, NAL's brief identifies several loopholes that this bill can and should close, including an overly restrictive definition of deepfakes, where abusers just have to make the image non-realistic to escape criminalization. So a deepfake set in a bedroom would be criminal, but the same deepfake where you change the background to be an under-the-sea castle now is no longer realistic, so no longer fits the definition of a deepfake. That's, again, an arbitrary distinction because the harm of the deepfake is not that people may think that the victim has done something sexual. The harm is that their sexual integrity is violated. We also point in our brief to a dual regime where some firearm owners who are domestic abusers lose their firearms, but not if they're police officers. And we also point and suggest closing loopholes regarding the use of sexual history evidence. I want to point out that both of these proposals and all other proposals in our brief come with specific drafted proposed amendments. I'm really happy to go through them in the question and answer period in more detail. Thank you.
Thank you very much, Ms. Zakour. Ms. Baird or Ms. Riendo, one of you will start us off.
Je vais commencer.
I'll start and my colleague will continue. Thank you for inviting us to testify on Bill C-16. Our organization actively advocates for the creation of a criminal offense of coercive control. We therefore welcome the Minister of Justice's initiative to include such an offense in this bill. In our view, criminalizing coercive control would lead to several significant advances for victims, as well as for society as a whole. It would provide a new tool to detect and address domestic violence more effectively, and above all, it would send a clear message to Canadians that all such acts are unacceptable, dangerous, and deserve to be reported. It would finally acknowledge that victims do not only suffer physical violence, but also all kinds of controlling behaviors, which are repeated day after day and have an impact on their lives, their health, and that of their children. Indeed, coercive control affects the entire family. Arbitrary rules and the imposed climate of tension and fear also affect the well-being of children who are co-victims. A comprehensive analysis of the accounts of victims and their children would break away from the narrow view of isolated incidents, which does not accurately reflect their lived experience. Criminalization would enable a more effective response from the judicial system to domestic violence by taking into account the context and history in which this violence occurs. Finally, since coercive control is a significant predictor of homicide, the creation of a new offense would provide an additional effective tool to break the cycle of violence earlier and thus adequately assess the danger posed by a situation of domestic violence through the proceedings. This criminalization must, however, be accompanied by measures to ensure optimal implementation. These measures are of the utmost importance. Indeed, some women's rights advocates fear that the criminalization of coercive control could backfire on the victims themselves. In particular, there is concern that more women will be charged than is currently the case in cross complaints. There is also concern that certain women will bear the brunt of this, including Indigenous women and women of color. Such concerns also existed in Great Britain, where we conducted 2 missions to discuss the concrete impacts of this criminalization with various stakeholders. However, these fears did not materialize. Through the conversations we had in England and Scotland, we came to understand that it was possible to avoid such unintended consequences. The solution lies in particular in training and equipping police officers and prosecutors so that they can properly assess the primary perpetrator when 2 partners claim or appear to have been victims. The lens of coercive control, which leads judicial actors to examine the presence of a pattern of behavior, combining repeated acts of control and coercion rather than isolated incidents, allows them to identify who is truly the abuser and who may have used violence defensively or reactively. Australia has established mechanisms for monitoring and reviewing cases to address the issue of perpetrators of violence exploiting the offense, and it is precisely to secure the time and financial resources needed to train all social and judicial stakeholders prior to the offense's entry into force, develop the necessary guidelines for police officers and prosecutors, strengthen legal and psychosocial supports for victims, and launch information and awareness campaigns for victims and the general public. That we request the section of the law concerning coercive control not come into force until 2 years after royal assent. Inspired once again by the Australian states we visited in September, we recommend that the implementation of this new section of the law be coordinated by committees of experts from the field at the national, provincial, and territorial levels, with the collection of police and prosecution data. This would ensure that this criminalization achieves its objectives and does not have unintended consequences. In this vein, we recommend that this accountability mechanism also result in a review of the law every 2 years for a period of 6 years. Regarding the amendments we propose to C16, we recommend changing the wording of certain sections that refer to security at risk to security threatened, as in the English version. This expression seems to require a less stringent burden of proof. Finally, we oppose giving police officers the measure to not use denunciation. This should also be done for prosecutors. And for the rest, we refer you to our brief. Thank you.
Thank you very much. Okay, we'll move into first round of questions for 6 minutes each, starting with Mr. Gill, I believe.
Thank you so much. Good morning, everyone, and thanks to the witnesses. In my community of Brampton, intimate partner violence has been declared an epidemic by Peel Regional Police. Peel Police responded to 46 intimate partner violence calls per day. That's 1 every 30 minutes. It is important to my community that we take the right step to end this epidemic. I would welcome every step we will take to stop crime and provide safety to Canadians. My question to Ms. Jacor, do you think that the government has gotten it right in this bill by making intimate partner murder a first-degree murder charge?
Thank you for the question. As currently drafted, we do not support the constructive first-degree offense, which is misleadingly labeled femicide, even though the offense is not gendered. The marginal note that calls the crime femicide is not part of the legislation. We support gendering that offense. And the reason is that if it's not gendered, it risks being used to over-criminalize the survivors who kill an intimate partner in self-defense. So they should be acquitted based on self-defense, but sometimes they do not argue self-defense and instead will plead to a lesser offense, which is currently manslaughter. And with this new provision, which we fear that some of these survivors will plead to a second-degree murder to avoid the first-degree murder conviction. So we recommend the committee recommend the committee gender that offense, so saying that it's the killing of a woman or a girl, like my colleagues also proposed.
Yeah. The government is calling murder of an intimate partner femicide. Is that actually what femicide is?
Well, no, as I was saying, so femicide has various definitions, but in all the definitions that I'm aware of, it has to be the murder of a woman or a girl. And if the committee changes that to the murder of a woman or a girl, then it makes it less important to limit that constructive offense to where there's coercive control. It could be an intimate partner, but only if that limit is placed to avoid backfiring against survivors.
And we know that liberal catch and release policies have deprived victims peace of mind they deserve. Regarding the Victims' Bill of Rights, you call for the governments to grant actual rights and remedies to the victims of crime. How has the government failed in Bill C-16 to put victims first for a change?
So Bill C-16 proposes changes to the Canadian Victim Bills of Rights, which are positive changes in general, but the Victims' Bill of Rights is premised on rights that are granted to victims, but without actual remedy. And there's actually a provision in the Bill of Rights that says that it does not grant an actual remedy where victims could sue someone if their rights are not respected. So that's what we propose in our amendment, to make sure that these rights, in law we sometimes say there's no right without a remedy. It means if you have a right, but nothing happens, if it's violated, then what's the point of having that right?
And your brief suggested amending Section 28 of C-16, removing the sections on treatment of a child or animal. What did the government get wrong on this, and how will it impact victims if left unchanged?
Excuse me, could you repeat the provision you're referring me to?
Section 28 of C-16, removing the section on treatment of a child or animal.
So the issue, like I said in my testimony, is that, again, survivors could be criminalized through this provision or threatened with criminalization, which is sufficient to prevent them from leaving an abuser, because there are cultural myths and stereotypes about mothers especially being controlling in the home. So we think this should be removed from the list. It's a non-exhaustive list, so if there's actual abuse being committed in any form, it can still fit into the offense, but this calls attention to the ways in which someone controls how people care for their children, and sometimes this is born out of safety concerns, so it should be removed.
And conservatives believe that this bill, while flawed, has some potential to protect victims and avoid re-victimizing them in the legal process. Do you agree?
I think there are some good provisions in the bill, but some of them that need to be amended to either prevent problematic sections of the bill or go even further in those sections that are positive developments, but making sure it covers all survivors and victims.
Okay. You mentioned that you don't want women to be criminalized if they use lethal force to defend themselves from their partner. Do you think that a change like that proposed in Bill C-270, the Conservative Stand on Guard Act, could address that?
So the question is not to say that women should not be criminalized if they kill an intimate partner. It's really in cases where it's self-defense. So these are cases where the killing is done to protect yourself. And the real solution, obviously, is to give women an out of these abusive situations, which we'll also discuss in the next bill you're studying in C-223, so that women can leave the situation and then they're neither killed nor kill their abusive partner. So that's where we should direct our efforts. But when the tragic happens and there is a murder of an intimate partner, if it's in self-defense, then the survivor should not be criminalized.
My question to Ms. Rando, I would like to focus on your organization's trip to Australia. You had issues with Australian laws criminalizing victims. Did the government make the same mistake with C-16?
So are you, je vais parler, excusez, en français, là.
I'll speak in French. I'm sorry. Which error in particular are you referring to? Because we're learning from Australia, and what we appreciated in some of the Australian states was the fact that they worked a lot on the implementation above and beyond the act being adopted. The state of New South Wales worked very hard on the implementation and ensuring that Committees of experts and forces were supervising the data, training in preparation of the implementation. There was accountability to determine whether the offense was achieving the objective set out by the legislator. Were their populations suffering more?
Oui, donc on apprend des choses, puis après, il y a certaines choses qu'on ferait différemment.
And then we learned about things that we would do differently from Australia.
Thanks, Mr. Gill. Mr. Housefather, over to you for 6 minutes.
Merci beaucoup, monsieur.
Thank you very much, Mr. Chair, and thank you for the groups of witnesses for their testimony. I will start with the NAWL.
First of all, let me just say that your brief is structured exactly in the way that I think everyone's brief should be structured. The way you explained each of your amendments and gave detailed legal language to us was exemplary, and I just want to thank you for that because it makes it so much easier for members of the committee to do their job. And for example, one thing that you pointed out, which is the ownership of an animal and the fact that the bill would require an animal to actually be owned by the person concerned and not their mother or not their sister. I mean, that was just a really interesting point that I hadn't noticed in reading the bill. So anyways, again, thank you. My first question to you relates to the question of protecting unreasonable women from criminal harassment. Can you just talk about your concern there and your proposed language and why that is important?
Thank you for your kind words on our brief, and thank you for the question. So there's two ways to criminalize causing fear in the context of criminal harassment. One is subjective fear, and that asks the question, was the person afraid? And one is objective, so would a reasonable person be afraid? And generally, you may not want to criminalize causing subjective fear because what if I don't know that the person is afraid? You know, I give someone a pen and that makes you afraid. It's unreasonable. I'm not going to be criminalized. But in the context of criminal harassment, there's already a requirement that the accused know that they're causing fear. So once I know, if my colleague tells me I'm very, very afraid of spiders, for example, it's unreasonable to be afraid of spiders, but I know it's the case. And in the case of criminal harassment, it's often intimate partners or former intimate partners. So I know intimately that the person has those fears. And once I exploit those fears and deliberately cause fear to the victim, then the question really is not whether the person was afraid. However, in our brief, we do propose to keep both objective and subjective fear. And the reason is that there's been a case in Quebec where the accused did something that would cause fear, so stalked a politician and harassed them. But the politician, instead of being afraid, was angry, and then the accused was acquitted. So I think that's what the bill is trying to respond
because
to.
A stronger person. What you're basically saying is a stronger person who doesn't feel fear that the average person would feel the matters which should still be a criminal offense.
Protect both the unreasonable victim and the resilient victim. It really doesn't matter how the victim lives their feelings. It's really focusing on the behaviors of the accused. So that's why we propose that dual standard.
Okay, thank you. I appreciate it. Is there something? So my next question is, can you explain to everyone the importance of changing the or to an and? In the bill, you have coercive or controlling conduct throughout, and you've, I think, suggested replacing that with an and. Can you explain again in terms of the pattern of abuse survivors why that's important?
Absolutely. So coercive control is already recognized in family law. So we're learning from how courts are dealing with coercive control in family law. And some of the ways they're dealing with that is finding that the victim is the abuser because they focus too much on control. And as I explained before, there's kind of this stereotype that if the woman is kind of constrained to the house, well, she's got control in the house. And sometimes judges really miss the power dynamic. And if the mother is trying to protect the children, for example, or protect herself, or say, you cannot drive the children around when you've had a few beers, or I don't want my ex to see the children right now because he's dangerous, and I'm afraid they might be harmed or killed. So that's when mothers can be in family law, they can be found coercively controlling, and now they're going to be maybe found to be a criminal. Even if they're not convicted, the threat of criminalization is already problematic. So the goal is to refocus on coercion and on power imbalance, which is the heart of coercive control. So we suggest changing the or for and, which is kind of the framing of the offense, in addition to the other change that I explained about being controlling at home. That's not coercive control how we intended.
I totally understand. I want to move to deepfakes now. I think Bill C-16 takes a very important step by expanding the offense of non-consensual distribution of intimate images to include deepfakes. It's something that I've called for a long time. One of the things that you've mentioned in the bill is the importance of including the word creating, meaning that a simple creation of a deepfake, a non-consensual creation of intimate images should be a criminal offense. Can you explain why? Because the bill currently talks about publishing, distributing, transmitting, but it doesn't talk about creating.
Absolutely. So we support the criminalization of creation of deepfakes for a few reasons. One of them is just understanding what is the harm of deepfakes. And again, the harm is not, some people might think that the victim has done sexual things. Like, that's really an, I think, outdated conception of what is the harm of deepfakes. The harm is using someone's image and body and recognized face and body to create sexual materials. If we criminalize the creation, first of all, that means that the law and the state can intervene before more harm is caused. Currently, creating deepfakes would be legal as long as it's not distributed, and once it's distributed, it's too late for the law to intervene. So we do recommend criminalizing the creation and also expanding the definition, because the definition is so narrow. It doesn't cover all sexual content. Needs to be explicit sexual activity, and as I already explained, the realism issue. So making it's a good step in a good direction, but if we're going to target deepfakes, we should target it in a way that will allow us to kind of intervene before more harm is created, and then intervene with the distributors of deepfakes.
Thank you, Mr. Housefather. Mr. Fortin, over to you for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. Thank you to all three of you for joining us this morning. This is precious testimony. First of all, the issue of femicide. In the definition, you said that they need to be crimes committed against women and children, and that struck me. I thought it was clear that femicide needed to involve a woman and a child. Can you just flesh out that definition a little bit more for us, please? Answer. Well, when you read the summary, you see, but when you read the section, it is a murder between intimate partners regardless of gender, and that's why we're saying that we need to clarify this. It needs to be clear that femicide is the murder of a woman or girl, and then it can be used as a behavior in spousal violence in cases of sexual exploitation. But at the outset, it seems important to clarify. You cannot assume in the bill that is what is meant. Question. How would you define femicide? First of all, it's a crime committed against a woman and a girl, and then I'll move on to something else because I only have 5 minutes. But would you put in the same category, well, I don't know, let's say a woman who is subjected to sexual assault and then killed, or is that the same as a woman who's killed by her spouse because there's coercive control? Or in a third case, there was the École Polytechnique, where there was an individual who killed women simply because they were women and he didn't even know them. Those are three different scenarios, and I'd like to hear from you. Are all three cases femicide, or should we draw distinctions? Answer. I think we need to specify that these are murders of women and girls because they are women and girls. So that would apply in the case of spousal homicide, because we know that if it happens in a dynamic of control, that element is important. It would apply for the Polytechnique case, but it would not apply in a case of a woman who's killed randomly. Thank you. And when we talk about a couple Well, let's take the example of a woman who is killed by her spouse. If she is murdered by her spouse, do we need to look at the reasons for the murder? For example, the spouse who says, well, there's insurance, life insurance on my spouse, I'm having money problems. I'm just making things up. But so I'm killing her because I could receive financial benefit from her death. Would that fall into femicide as well? Or do we need to draw a line and he'd say, well, no, he's killing her because she looked at the neighbor a bit too long? Or I don't want to seem insensitive, but I'm just trying to understand what's meant by femicide. Answer. For us, it's obvious that it's a situation where there is a type of behavior. Because if it's not there, a murder, for example, of someone who is defending themselves against their spouse, violent spouse, you might think that that's also a first-degree murder. For us, the important thing is that it's demonstrated that there was a type of behavior, a situation of spousal violence that results in murder at the end of the day. Thank you. I'd like to come back to what you talked about earlier in your testimony, the issue of legitimate defense. It seems to me that that's already set out in the criminal code, that whether it's a man or a woman, cases of legitimate self-defense are already set out. Should we add something specific for legitimate defense of a woman who's victim of controlling and coercive behavior, or is the current definition for legitimate self-defense sufficient? I'll start and then allow my colleague to continue. One of the issues sometimes is proving the legitimacy of self-defense, and that's considerable stress. There are cases currently where a woman who allegedly killed her partner in legitimate self-defense could currently see herself accused of second-degree murder and manslaughter. So there's pressure to say, well, do I take the risk of... I'm sorry. There's a lot of discussion. Mr. Chair, I'm sorry, but there's a lot of noise in the room.
Colin, the witness is having trouble hearing, and I'm having trouble hearing as well, if you don't mind. Thanks.
Merci, Monsieur le Président.
Alors, ce que je
Thank you, Mr. Chair. So what I was saying is that it's not guaranteed. A woman could be charged with, even when there was a legitimate self-defense, would I take the risk? Perhaps I'll plead guilty to manslaughter, and sometimes she is advised by a defense attorney to do so, even when it was legitimate self-defense. So we think that this is an additional guardrail to have this prerequisite that there be this type of behavior to avoid criminalizing victims, as my colleague said. In what cases... A woman, for example, who killed her spouse, who tried to kill her, for example, in what cases will she have to invoke particular criteria for this legitimate self-defense, and in which the current principles of a legitimate self-defense are not sufficient? Can you give us examples? Perhaps I'll jump in. Normally what we see is that historically, legitimate self-defense was against an immediate attack. Women who kill their spouses, generally when there's an immediate risk, it's too late. So they may have called the police on a number of occasions, so that perhaps there's no other way for her to get out of it alive. The courts have made place to recognize that type of legitimate self-defense, but it's always a bit risky, as my colleague explained. So perhaps you're looking at imprisonment for life, or perhaps she's or pleading for a lesser offense, and sometimes the legitimate self-defense fails, and the solution is not a type of compromise for a lesser offense. It's really life imprisonment for murder.
Thank you, Mr. Fortin. Mr. Brock, over to you for 5 minutes.
Thank you, Mr. Chair, and thank you, witnesses, for your attendance today. I, too, want to thank you, Ms. Zakur, and I share Mr. Housefather's compliments to you. It was a well-structured submission, and I would encourage all witnesses to take that as an example. It certainly aids us in the work that we have to do. Excuse me. And I know that you and I have spoken online in advance of your testimony, and we talked generally about your submissions, and we certainly did not get through all of them. So I don't want to repeat a lot of the opportunities already presented by several members to you, but I do want to circle back on some things that I think you have not commented on, and I want to start off with the firearm issue. You specifically addressed that as a gap in C-16. So I want to get through maybe 5 or 6 different examples in the 5 minutes I have. So if you could keep your remarks pretty concise, I can get through my entire list. Thank you.
So a couple years ago, Parliament amended the Firearms Act so that people who commit domestic violence, family violence, there are different ways to get at that result, but lose their firearms. And this will only apply to people who are subject to the Firearms Act regime, which excludes certain professions, including police officers. So that means that a police officer who is an abuser can keep their work firearm, and we know there are high rates of domestic violence among police officers and other professions. So we suggest mirroring that new regime in the criminal code so that it also applies to police officers. And there's other small loopholes that are very technical, but that are being close to just fulfill Parliament's intent to make sure that if someone is an abuser, they don't have access to firearms, to avoid the femicides.
Thank you. You also speak at great length about the concerns you have regarding the introduction of sexual history evidence, particularly under Section 276 of the Criminal Code. Can you expand upon that?
Absolutely. So this comes from some research I've done outside of my work at Null as well, where the Criminal Code prohibits accused people from using the victim's sexual history evidence to kind of diminish their credibility and argue that they consented to the sexual violence. And from my research, I see that there are gaps in how courts interpret that. So the accused will not be able to say, let me bring in some sexual history evidence to show that she consented. Instead, they say, let me bring in some sexual history evidence to show that I believe that she consented. So they'll say something like, well, I thought she consented to rough sex because she's consented to it in the past. So that does not ground a valid defense in Canadian criminal law, but is being used to introduce sexual history evidence. So we suggest expanding what are the twin myths, that is why you cannot introduce sexual history evidence, to now those 3 scenarios to protect victims' privacy and sexual integrity and the integrity of the criminal justice process.
Thank you. On the same issue of records, you also had concerns regarding personal records, and that specifically the bill talks, and the current legislation only speaks about therapeutic records. Where is the gap in C-16?
So there's been concerns by survivors that we need to raise the threshold from admitting these highly sensitive and often not very relevant records. And the kind of usual response is, well, it would not be constitutional to ban the use of these records. But then the government is deciding to raise the threshold for the therapeutic records. So we believe it's a belief that this is a constitutional threshold, since that's what's proposed in the bill, but then makes a very rough distinction between a therapeutic record and every other record. And there's no reason to believe that all therapeutic records are more sensitive than all non-therapeutic records. I gave the example of child protection records, sexual assault centers records. So if the government and this committee believes that this standard of raising a reasonable doubt to guilt or innocence is a constitutional standard for the production of records, just raise the threshold for all the other records and also avoid the need to debate which type of record something is, and just make it consistent to protect victims' privacy.
Okay, I got time for one further area to explore, and that's on pub bans, publication bans. Your comments on that, where C-16 is lacking.
So again, a couple of years ago, Parliament amended the publication bans regime to make it more difficult to criminalize survivors who share their own story. And what we're hearing from survivors is they didn't go far enough, and it's still problematic. Survivors can't get a straight answer from a lawyer on whether they can or cannot do something. Survivors can share their story, but it's not clear that they can share their story in the media. So we suggest just making it clear that publication bans are bans for other people not to share the identity of the victim survivor, and not a ban against the survivor sharing their story. Currently, if you are a victim of sexual assault, you can share your story, except if there's a criminal trial, which is can cause problems. So that's why we suggest kind of revisiting and expanding the protections for survivors.
Thank you very much, Suzanne.
Thank you.
Great. Thank you, Mr. Brock. Okay, over Ms. Latanzio for 5 minutes.
Merci, Monsieur le Président. Donc, bienvenue.
Thank you, Mr. Chair. Welcome to everyone this morning. It's a pleasure to see you again. The first time I saw you, it was during a consultation on this bill. Thank you also for your very complete and appreciated briefs. You propose in the brief to distinguish the provisions related to femicide from those concerning hate crimes. I'd like to hear from you on how this would improve the legal clarity and the specific recognition of gender-based violence. Answer. We ask for this distinction because there can be hate crimes against women, specifically against women like what we saw at École Polytechnique, but there can also be hate crimes against other categories of people, against people of a certain religion or other characteristic, and it seems to us that in those two cases, that could be considered first-degree murder. That is why we are asking for the distinction. Question. And you also highlight that the notion of coercive control would allow us to exceed the logic of isolated incidents. Do you think that without this change, we won't be able to get past the early stage and it will help us avoid the deadly escalation of violence? Thank you for the question. In recent years, we have trained over 14,000 legal actors, including police officers, and some of them are currently missing criminal code behaviors. Some behaviors do not meet the threshold of harassment. There's financial control, for example. Many elements that are very dangerous, but knowing that a third of spousal homicides do not contain a physical aspect, police officers are missing a tool to intervene, to detain people. And so for us, it is essential that this criminalization happen. It's not the only measure, but it is essential for protecting many women who currently are not being protected by our legal system. Thank you. And can you tell us in general terms why, in your opinion, this bill is a significant step forward, specifically concerning the recognition of coercive control and the dynamic of spousal violence? And what components do you think are particularly positive in its current form? Well, first of all, and it was evoked in Australia, the main factor that caused survivors to vote in favor of it was the denunciation, that society understand that this is unacceptable and dangerous. And for survivors, it was a public denunciation, a clear message to society. Yes, it can also act as a lever, can allow prosecutors and police officers to get upstream of femicide, to stop the violence at the outset. When it comes to victims' trust, how many times have they been told, what you've experienced is serious, but it's not serious enough? So they get the feeling with coercive control that they finally have a recognition of all of what they have lived through. You're not a victim of spousal violence on February 24th and September 16th. And the prosecutor said, it's not a photo, it's a film. And the recognition of coercive control in the criminal code recognizes the lived experience of victims, their children, and the impact that it can have. To recognize the obstacles to separation. People are told, why don't you just leave them? But that's very dangerous. And criminalization of coercive control provides tools, but also validates victims' feelings about the process as well. And we talked about this earlier. It can give help analyze a main aggressor. It helps us take a step back because currently we analyze isolated incidents. What happened today, April 13th? And they don't look at previous behavior. Coercive control is telling them what's happening in the months, weeks, and years before. And it helps clarify the gravity of the offense, the danger, but also create a better safety net around victims. Concerning the effectiveness of this bill, how, in your opinion, could this bill improve access to justice and protection of victims, but particularly access to justice? Answer. We think that for this bill to make a difference, there need to be essential conditions. There needs to be training of police officers and prosecutors so they can recognize coercive control, document it, bring it in as evidence. Directives need to be given to them. There needs to be accompaniment of victims at the social and legal in the social and legal spheres. And that's why we are saying that all of these measures need to be put in place at the same time as the bill, because a single section will not change everything. We saw that for a number of years after the creation of criminal harassment, it was poorly applied. They thought that there needs to be repetitive. If we want to improve access to justice, we need to put in place the necessary conditions, and we need to monitor what we're doing to ensure that there are no unintended side effects, and to protect victims and review if needed. Mr. Fortin, 2.5 minutes. Thank you, Mr. Chair. Ms. Barrett, well, first of all, obviously, the issue of coercive control is a scourge that we need to root out. We've talked about this for a number of years now. But we have had a number of parliamentary adjournments, and so we're coming back to it now. And I'm happy about that. That being said, Madame Barrett, you said, and I perhaps misunderstood, I'd ask you to explain. You talked about waiting for 2 years before coming into force. I was a bit surprised by that, because I've heard testimony about the urgency of acting quickly. And you talked about a review every 2 years, and that seems reasonable to me. But concerning the coming into force, I'd like to hear more from you on that. Well, we're very eager for it to come into force. I'll be clear on that. We have been waiting for other legislation, but we're happy with C-16. But we don't want unintended side effects. The issue in England, when they first criminalized coercive control, it meant that some stakeholders were trained, police officers first, but prosecutors were not trained and they were unable to mount a case, and so things fell through the cracks. So the entire chain needs to be equipped and trained, because if they are not, then victims are disappointed because they are knocking on the doors of police stations and then their cases don't move forward. And in other scenarios, there's bad case law that really creates a long-term issue. Secondly, we're a big country. Other jurisdictions, sometimes there was one national police body. They have a single police service. But we're looking at all of Canada. In Quebec, we're lucky to work on coercive control with legal stakeholders, and it's working well. But it takes time to train people, to develop tools, to ask the right questions about when they're taking a statement. Tools were developed in Quebec, but we need to ensure that across Canada, there is training upstream of the coming into force. So we can't rush through this and build the plane while we're flying it. There need to be optimal conditions so that there aren't unintended side effects. So that's why there's 2 years. We need to be given the means to do things properly.
Merci.
Sorry.
Merci.
Mr. Lott.
Thank you very much, witnesses, for your thoughtful comments on this. I'd like to delve into the deep fake aspect, Ms. Zakour, because this is something where, the laws are updated less frequently than the technology is advancing. And we've seen, even in the last few months, some really rapid changes. I had a friend of mine that was targeted by someone using Grok to put her in a state of undress, and it was, to your point, incredibly humiliating for her. But I also want to make sure that we are not so broad with what we do that we're limiting things that probably shouldn't fall under criminal law. So I want us to get it right. So I'm hoping just to work through some of your suggestions on this. One of the things that you mentioned in your proposed amendment was the idea of using near nude as opposed to just nudity or sexual behavior. Another thing that you've talked about is eliminating the realism component. So just to use an absurd example from that, if someone were to put someone's face on The Little Mermaid, wearing a clamshell bathing suit top underwater, would that, in your view, fit what you think should be captured by this definition of criminal law?
Thank you for the question. So the nearly nude is necessary to cover situations of being undressed in a bikini, like put her in a bikini kind of thing. And the removing the realism is necessary to address the issue of just changing the backgrounds and making it like a different setting that I addressed. I believe what the realism was trying to get at was recognizable face and body. So it is up to you as a committee to decide if that's the threshold you want to keep, recognizable face or body, or only recognizable person. So if you put someone on a dog's body, well, that would be an example where you can make that decision. But that's not a question of realism. It's more recognizable person that would cover or the Little Mermaid deepfake or something like that with someone's face. Yeah. So that would be just recognizable person, or you could do recognizable or a reasonably, one of the ways we propose it, reasonably convincing manner, which would not have to pass a test of realism. I believe it's true, but it's reasonably convincing that it actually depicts the person. So there are different ways you can make that threshold.
So I've always viewed this issue as being where the threat comes from believing, or people believing, that a photo or video is real, and that's the harm. Your view is that isn't actually the harmful component. It's just the degradation or the humiliation that comes from the image itself. Do I understand that correctly?
Yeah, so some examples that we've seen is victims of crimes who had died were then being put into deepfake. So that is not, everyone knows that the victim has died and it's not realistic. So engaging in sexual activity is not shameful per se. It's not the fact that someone may have engaged in sexual activity. It's really the non-consensual part. So it's the difference between wearing a bikini because you want to wear a bikini and someone forcing you to undress is completely different. So yes, we believe the harm is in the non-consensual use of someone's image for sexual purposes, not the fact that the person is believed to, be sexual or have had a sexual past.
What view, if any, do you believe that civil law could play in this? Because again, criminal law is a very, very big tool. Could there be a route through defamation or privacy where people have a remedy, but we're not threatening to throw someone in jail if they make an image that is, again, humiliating perhaps, but not something that people believe is legitimate? I don't know where I am on this. I'm just trying to understand what our options are as we deal with this issue.
So what victims most want is a remedy to take remove the photo from the internet. That is, I think, what the number one thing that the online harms kind of remedy, and that is starting to appear in different jurisdictions. I always make a point of arguing for things that you can do in this, this is in the federal jurisdiction. But yes, what victims want is for the image to disappear. That's why by targeting the creation, that might also enable the law to intervene with the companies that diffuse these, that share these images. But yes, there's definitely a role for civil law. But civil law, if it's just defamation, it takes time and it's too late. It's really removing the images. But within our proposals are limited to federal jurisdiction. But yes, absolutely, that would be part of the solution. And it's also the teaching what is acceptable and what is not acceptable. And if the limit is different in civil remedies and online harms and criminal law, it may create confusion, but definitely it must be part of the picture.
Thank you, Mr. Lawton. All right, Mr. Chang, you're next. I'll give you about 3 minutes, and then we'll have to stop. Thanks.
Thank you, Mr. Chair. Ms. Zakor, we know that many victims delay in leaving abusive relationship because their shelters cannot accommodate their pets. Which creates a real barrier to safety. So from your perspective, are there any legal or policy measures that would accompany Bill C-16, such as protection order for pets or better coordination with shelters to ensure victims can leave safely?
Well, yes, that is a real issue, and it's an issue that is related to shelters not having enough money and also not accommodating the pets. And I believe some of the briefs that were submitted touch to that specifically. But yes, we do support solutions that include recognizing that the harm to the animal is part of the dynamic of coercive control and domestic violence. It's the same abusers who abuse the mother, the child, and the pet, and it should be seen as one issue that needs to be addressed in all its facets.
Thank you. And there has been discussion about defining femicide as the killing of woman and girl. Based on gender or sex. To ensure legal clarity and no victims are excluded, how should the law be applied in cases involving gender diverse individuals? For example, in a gay relationship where one of the partners identifies as a woman. So based on your experience, what approach can ensure the definition remains legally clear, inclusive, and focus on the underlying dynamics of gender-based violence?
So I think the one premise that's really, really important is that murder is already a crime, and it's really about this. The government is deciding that they want to do something more and something special to recognize femicide, but murder is already a crime, and it's the most serious crime in the criminal code. So no one will fall through the cracks in that way. That being said, if the government decides to go forward with this femicide legislation, which raises a lot of issues, the definition of femicide as a woman or a girl would be a way would be more specific, and it would have to include both cisgender and transgender women and girls. It's also possible to decide to define it as murder of a woman or gender diverse person. And it really kind of depends what is the purpose of this new legislation, because if a lot of the situations that are covered in this bill actually are already covered as either first-degree murder or aggravating factor. But yes, that are kind of different options that could be used. It's also possible that maybe what the government is trying to target is not femicide, and it's something else. But if it's femicide, then femicide would be the murder of a woman or girl because of her gender, whether it's a cisgender woman or a transgender woman.
Thank you very much.
All right, thank you, Mr. Chang. Thank you to our witnesses. Unfortunately, that's all the time we have for this panel, but we're very grateful for taking the time and making such excellent contribution to this important piece of legislation. So thank you. We'll suspend for a couple of minutes till the next panel's ready. And for our second hour, we are joined from the Barreau de Quebec, Sylvie Champagne and Michael Marchand, and from the Macdonald-Laurier Institute, Peter Copeland, and the Provincial Association of Transition Houses of Saskatchewan. We have Dr. Crystal Guybreck, who I understand may be having some sound challenges, so I'm going to ask you to go last in the opening remarks. Each group has up to 5 minutes for opening remarks, and then we'll open the floor to questions. So why don't we start with the Barreau de Quebec?
Monsieur le Président.
Mr. Chair, committee members, thank you for giving us the opportunity to present the position of the Quebec Bar Association as part of the review of Bill C-16. The Quebec Bar Association is the professional body that regulates the practice of more than 31,000 lawyers. Its mission is to ensure the protection of the public, to contribute to accessible and high-quality justice, and to uphold the rule of law. In this capacity, the Bar acts independently to inform the legislature through rigorous legal analysis grounded in the realities of the justice system. We rely on the invaluable collaboration of our expert groups composed of lawyers who reflect the diversity of our profession. From the outset, I would like to emphasize that the Quebec Bar Association supports the fundamental objectives pursued by Bill C-16. The desire to better prevent and punish domestic violence, to recognize the dynamics of domination that can lead to homicides, to strengthen the protection of children, and to adapt the criminal justice system to certain contemporary realities is legitimate and necessary. Our comments are therefore not intended to call these objectives into question, but rather to support their achievement. Allow me to briefly present the main components of our analysis. Number 1, consistency and clarity of criminal law. The bill amends the offense of criminal harassment, creates a new offense of coercive control, and introduces a classification of femicide. However, these three mechanisms are largely based on the same core behaviors, namely surveillance, intimidation, control, and isolation. The Bar Association fears that this proliferation of offenses centered on similar behaviors unnecessarily fragments the understanding of domestic violence and complicates the application of the law without offering any real increase in protection. We believe that a more integrated approach would have allowed the same objectives to be achieved more clearly and effectively. I would now like to focus on the issue of femicide. The Quebec Bar fully recognizes the importance of identifying and combating homicides that occur in a context of domination, control, and gender-based violence. This is a serious, well-documented reality, and it is legitimate for the legislature to wish to address it seriously. Two key elements deserve clarification to ensure this reform fully achieves its objectives. The first concerns the temporal link between the violence inflicted and homicide. The bill allows a murder to be classified as femicide not only when it is committed during a period of control or domination, but also after such a pattern has existed without clear parameters. The broader and more imprecise this temporal link is, the more difficult it becomes to establish a direct connection between controlling behavior and the act of killing, which can create uncertainty in the application of the law. The second issue concerns the balance of the justice system. A conviction for femicide automatically carries the most severe penalty under Canadian law: life imprisonment without the possibility of parole for 25 years. This exceptional penalty is normally based on the idea that the act committed reflects a particularly high degree of culpability. If the definition is too broad or insufficiently defined, there is a risk that this maximum sentence will apply in situations where the link between control and the homicide is not sufficiently clear or direct. The Bar Association therefore urges the legislature to tighten certain parameters, particularly by clarifying the required link between the dynamics of control and the homicide, so that the classification of femicide precisely targets the situations it aims to address. The third part of our brief concerns mandatory minimum sentences, previously declared unconstitutional, accompanied by the new mechanism proposed in Section 718(4) of the Criminal Code. Although presented as a tool for flexibility, this mechanism effectively shifts the burden onto each defendant to demonstrate that the mandatory minimum sentence is unjust in their case. This raises concerns regarding fairness, legal predictability, and the risks of a two-tier justice system depending on the resources available to the defendant. And finally,
Oui. Alors,
yes, so we'll come back to this with questions, but on the Jordan Principle, we have concerns. Thank you for your attention, and Mr. Marchand and I would be happy to answer your questions.
Thank you very much. Mr. Copeland, we'll go to you next.
Thank you, Chair, and to everyone for having me. It's a privilege to be here. The protection of victims is at the core of public safety, and the federal government deserves credit for taking up several politically fraught issues at once, both long-standing and novel. But it's one thing to be able to tackle these problems, and another to ensure the policies are crafted in such a way that they meet the objective in substance and not just in style. 10,000 cases stayed or withdrawn annually is an affront to justice for the accused, victims, and our general public safety. And at MLI, we've argued that legislative refinement of the Jordan framework is warranted, as the court's ceilings were not the product of data-driven analysis and institutional knowledge, but legislated from the bench. Parliament is on firmer ground when it deploys the additional resources and time they have at their disposal to find an appropriate solution to the issue, as they have here. The bill's amendments are welcome in this regard, but should go further by expressly recognizing organized crime and national security matters as categories that warrant special treatment, as they involve unusually document-heavy, operationally complex, cross-border evidence, multiple accused, and intelligence sensitivity issues. The image-based abuse reforms are among the strongest parts of the bill, but they too do not go far enough. For many victims, the core harm is that images stay up for far too long. Canada should learn from the recent American legislation, as we argued at MLI with Bridge to Future. This means a 48-hour takedown capacity with expectation and consequences for platforms that fail to act. The concept of coercive control is well known and can be operationalized in a way that is precise. The bill is directionally right to include it, but the definition is dangerously loose as drafted. What counts as a pattern is undefined. Is it 2 acts or is it 10? Over what period? When does basic financial management become coercive control of economic resources? When do basic domestic disagreements, say about parenting, become control over the manner in which a child is cared for? The definition, we argue, should be amended in line with what the concept in fact is: a sustained pattern of domination, intimidation, isolation, and threatened consequences that deprive a person of ordinary agency within an intimate relationship. To achieve that, a predicate offense rather than standalone model where multiple acts defined over a period of time, and perhaps with Crown approval, would be superior. It would avoid excessive overcharges and the capture of basic disagreements and absurd scenarios, as I've illustrated, that could gum up the justice system. Scotland adopted this predicate approach and had 95% prosecution rates, whereas England, the loosely defined model, akin to what's in this legislation, and its success rates were 13%. On to femicide. Argue the language should be removed, and can be without sacrificing any of the additional offense types or the severity that it is to be rightly associated with. Unlike organized crime, for example, which recognizes patterns of behavior and clusters of offenses under a concept with additional powers for police and prosecutors, along with penalties associated with it, femicide is a misleading term. It implies someone has the intent of killing based on generalized misogyny. In reality, people generally have specific motives related to concrete facts and realities, not a generalized hatred of women. Parliament is already ensuring harsher treatment for killings committed in the context of coercive control, sexual violence, trafficking, or hate through this bill. And the law can specify those aggravating features, require courts to consider more serious sentences where they're present, and improve statistical tracking of violence against women without adopting activist terminology that is effectively a distinction without a difference. And lastly, minimum sentencing. The government's right to reassert Parliament's authority in this regard, but the safety valve approach remains too deferential to the same jurisprudence that created the problem. Courts have stretched Section 12 to second-guess sentencing policy that properly belongs to legislatures and could do so again here. They could find, for example, that offenders' race or migration status warrants this special treatment, as they have been prone to. It's important to remember that there is in fact already a great deal of discretion in the law. Police decide what facts justify charges, prosecutors decide how to proceed, and in many cases the Crown can elect by indictment summarily or a different offense altogether depending on the facts before them. A better model would be mandatory minimums with a set of narrow and objective grounds that, when coupled with gross disproportionality, could qualify the offender for a lower sentence. Things like the age of the victim, prior conviction, use of violence or threats. That would preserve Parliament's sentencing signal and reduce opportunities for imaginative judicial revision. So to conclude, Bill C-16 is genuinely impressive in its scope and intent, but it must go beyond that to ensure the laws are properly tailored to address the problem they're meant to and include less symbolism beyond what may be attractive politically or most expedient to carry out.
Copeland. Okay, our last presenter then is Dr. Guybrecht for 5 minutes.
Good day. I'm Crystal Giesbrecht, and I'm pleased to add the perspective of PATHS, the Provincial Association of Transition Houses and Services of Saskatchewan. I will focus on the provisions in Bill C-16 regarding coercion or control of an intimate partner, specifically PATHS support for legislating a criminal code offense, and 4 potential amendments to this section. I have submitted a brief regarding these recommendations. I conduct research with survivors of intimate partner violence and coercive control and service providers in Saskatchewan. Without exception, PATHS member agencies, as well as survivors and professionals who have participated in PATHS research, have expressed support for criminalizing coercive and controlling conduct in the context of intimate relationships. We appreciate the inclusion in Bill C-16 of a comprehensive description of coercive or controlling conduct that acknowledges the nature of coercive control, where incidents on their own may appear inconsequential, but where the cumulative pattern causes harm. Importantly, this bill will criminalize this pattern of conduct when it is perpetrated against an intimate partner or others, including children or the survivor's animal. Canadian research demonstrates that children are often co-victims of coercive control. My own research in Saskatchewan, as well as that of other researchers across Canada, has demonstrated the connection between coercive control and threats, maltreatment, and abuse of animals. We suggest expanding the definition to include engaging in a combination or repeated instances of any of the forms of other conduct listed if the victim states that they believe or that the behavior could reasonably be expected to cause the victim to believe that their safety or the safety of someone else, including their animal, is threatened, or they have experienced distress, disruption to their life, or an adverse effect on their day-to-day activities. This will allow accountability for coercive or controlling conduct that disrupts victims' daily lives, regardless of whether the behavior could be expected to cause victims to believe that there is a threat to safety. Second, we recommend including manipulation of the victim's vulnerabilities as another possible form of coercive or controlling conduct, as opposed to being considered separately under circumstances. Although this provides guidance on an area that may be considered rather than a mandatory element that must be present, we feel that this change would keep the focus on the behavior of the perpetrator and limit the evaluation of the victim's circumstances of vulnerability in the court's determination of whether the perpetrator engaged in coercive control. Third, We recommend an amendment to state that when a person is convicted of an offense under Section 264.1, the court will make an order prohibiting the offender from contacting the intimate partner or any child or other person affected by the conduct unless satisfied that the order is not necessary for the safety or protection of the victim, any child, other person, or animal affected by the conduct. And fourth, we recommend an amendment to establish training guidelines and programs for legal system professionals in consultation with provinces and territories, police, intimate partner violence and coercive control experts, and organizations that work with victims and survivors, and to require monitoring and reporting on training implementation. The section pertaining to coercive or controlling conduct is set to come into force 2 years after royal assent. Therefore, training for professionals must take place during this period to ensure effective and informed responses when the legislation comes into force. Professionals who will require training on coercion or control of an intimate partner and the new offense will include police and lawyers. Training should also be made available to judges. In the brief, we've listed topics for inclusion in training, including moving from an incident-based view of intimate partner violence to recognize patterns of coercive and controlling conduct and practical skills, such as risk assessment and evidence gathering. In conclusion, I want to reiterate PATH's support for a criminal code offense of coercive or controlling conduct toward an intimate partner. We hope to see the Protecting Victims Act become law in Canada. Sincere thanks to the committee for your consideration.
Thank you very much, and apologies, I mispronounced your name at the outset. All right, Mr. Baber, I'm turning it over to you. You have 6 minutes starting now.
Thank you. Welcome, Mr. Copeland, and thank you for your testimony. I'd like to address your article in the National Post concerning the mandatory minimum sentences. I've long maintained, and my friends have long maintained, that this Liberal government has abdicated its responsibility on keeping Canadians safe vis-a-vis an explosion of crime since its election in 2015. And you write, although correlation is not causation, it's noteworthy that a decade-long rise in crime rates coincided with the return of the Liberals to power in 2015. Can you please expand on that?
Yeah, so during this time, there were hundreds of instances at the federal level and other superior courts across the country where minimum penalties were struck down, and they're often done so on the basis of a reasonable hypothetical scenario that, a judicial innovation that allows the judges to assess hypothetical scenarios and not the facts before them. And so, we saw numerous minimum penalties struck down during this time. And I think one of the benefits of minimum sentencing is that they are in fact very clear and straightforward, and so they create predictability and certainty of enforcement, which is in fact a deterrent. It's not about the severity and length necessarily of time spent, and we want to ensure our penalties are commensurate with that, but they are a very efficient and effective tool.
Thank you, Mr. Colvin. If I may, you're saying that in support of the various courts striking mandatory minimum sentences under Section 7, they often cite what is referred to the fundamental Canadian values test, a vague and non-legally justified concept. Can you please explain what you mean by the courts resorting to the fundamental Canadian values concept to strike down a mandatory minimum sentence?
Yeah, so that's in reference to charter values, and this is I think an example of something in which courts take it upon themselves, unfortunately too often, to refer to things not in the text of the law as a basis to inform their judgment, and I think that is too often what occurs in the area of criminal law. And so, returning to these specific proposals, we do commend the government for taking it upon themselves to reinstitute the mandatory minimums. But I do have a concern with the nature of the safety valve, in that it still invests a lot of discretion with the judge to on their own interpretation of what constitutes cruel and unusual punishment to basically come up with scenarios that, in their view, constitute cruel and unusual punishment, when in fact many Canadians would disagree. And so go ahead.
I apologize, my time is short. So just for the benefit of the viewers at home, I'd like to try and explain what is happening vis-a-vis this argument on mandatory minimum sentences and what the government proposes to do. So, like we saw recently in the Seneville decision, in which the Supreme Court struck down the mandatory minimum sentence for access and possession of child pornography, the court relied on a reasonable hypothetical where two teenagers supposedly would send each other an explicit picture, and that may be tantamount to possession. And of course, the court said, well, that would be absurd. And so because of that, you can't maintain the minimum sentence. That was not the case before them, but they decided to strike down the mandatory minimum sentence on a basis of a hypothetical that, in my view, no respectable Crown or police officer will touch. And so what they've done is they've reduced sentence to Seneville, and in fact, in Nod's case, to 9 months instead of the mandatory 12 months. And this is despite the fact that Nod never argued that that a mandatory minimum sentence of 1 year would be cruel and unusual. And so the court strikes it down on a hypothetical, but awards the defendant Nod with a lower sentence than is prescribed. Now the government comes along and says, okay, we're going to use a safety valve. We're going to say that we're going to allow for these extreme scenarios that would allow a court to escape from the mandatory minimum sentences. But I submit what it in fact does is it weakens mandatory minimum sentences, and that it still allows judges, like in the Nod case, to disregard the mandatory minimum sentence, even though absurdity was not pled. Mr. Copeland.
Yes, I do think that it's conceivable that relying upon a creative interpretation of what constitutes, I can't remember the exact language, grossly disproportionate, cruel and unusual punishment, even restricted to the facts of the case, you could find judges striking down laws and not rendering justice. And so, as I suggest, a way of narrowing this further could be tying certain objective factors to to make a lower sentence eligible, someone eligible for that. Things such as age, prior convictions, whether there is a commercial purpose involved, threats, intimidation, the presence of weapons. This is used in other jurisdictions, and they have the effect, I think, of constraining the judiciary appropriately and ensuring that the intent of the legislature to ensure, severe punishment of an offense is upheld.
Thank you.
Thank you, Mr. Baber. Mr. Chang, to you for 6 minutes.
Thank you, Mr. Chair. My first question goes to Dr. Gebrich. How transformative is the recognition of coercive control for frontline service providers?
Thank you so much for the question. I think this will be hugely transformative. A criminal code offense of coercive and controlling conduct is something that frontline service providers have been calling for many years. We at PATHS, on behalf of our member agencies, domestic violence shelters and counseling centers across Saskatchewan, have been advocating for this to the federal government for nearly 7 years. I think so often, frontline service providers, and that includes family law professionals, it includes police, and also domestic violence shelter and service workers, have instances where they're supporting clients who are at a very, very high risk of lethality. They're experiencing some very dangerous and harmful behavior, but currently there's nothing within the criminal legal system that can be done to support them. So by legislating this criminal offense, I think it opens a lot of doors for training, education, awareness of what coercive control is, and it offers frontline professionals a way to support survivors and direct them to mechanisms within the criminal legal system that can help them and to keep them safe.
Thank you. And why is the 2-year implementation period important for training and system readiness?
Yes, so I would echo what our colleagues at the regroupement said earlier, and I of course, we've wanted this criminal offense for a very long time, and I would love to see coercive control criminalized immediately. However, I do recognize why this has been put into the bill, and I think having that 2 years before it comes into force will be helpful for ensuring that training is provided to legal system professionals, police, lawyers, prosecutors. However, that 2 years will need to be used very efficiently. Training will need to be ready, and it will need to be rolled out and monitored and ensured that it is implemented effectively, so that those 2 years are used to ensure that everyone has the training and there's going to be effective responses in implementation as soon as that bill comes into force. If those 2 years are not used to efficiently and effectively deliver training for professionals across the country, then the 2 years won't have met its objective.
Thank you. And what specific training should police and prosecutors receive to apply this law effectively?
So I think the training should include a number of topics, and not an extensive list, but I think some of the things that could be included in that training include the range of behavior and tactics employed by perpetrators, the connection between coercive control and other forms of intimate partner violence, the connection between coercive control and intimate partner homicide or femicide, moving from an incident-based view of intimate partner violence to recognize patterns of coercive and controlling conduct, recognizing the cumulative harm of coercive and controlling behavior and the impact on victims, cultural and intersectional factors that impact the perpetration and experience of coercive control, and practical skills for professionals such as assessing risk, including risk of lethality, identifying the primary aggressor, interviewing survivors and perpetrators or accused perpetrators, gathering evidence, documenting patterns across multiple interactions and calls for services, and trauma and violence-informed support for survivors, and very importantly, cross-sectoral collaboration.
Thank you. And do you believe making femicide first-degree murder sends a strong enough message, a strong enough deterrent message?
I do. I think that valid points were raised by the presenters in the first hour of the committee's meeting about some of the gendered issues of the recognition of femicide, but I do think that this is very important, and I'm in support, and I'm heartened to see the issue of femicide addressed in Bill C-16.
Thank you. And how will this bill change the way victims are identified and supported?
I think that by having a criminal code offense of coercive control, this offers opportunities for victims, first of all, to report. Currently, right now, and I see this through my work with frontline professionals and also with victims and survivors of coercive control, that many of them do not report to police because there's currently no chargeable offense occurring. So being able to report means repercussions for the perpetrator, but importantly, it means the potential to offer protective mechanisms such as protective orders to survivors, and also to be able to validate and recognize that behavior and be able to show that this does matter and it is concerning and it's potentially dangerous, and to be able to do something about it. Whereas the current status quo is that victims and survivors are told, well, there's nothing we can do here. There's nothing we can do about this, or come back when something criminal, i.e. a physical or a sexual assault occurs.
My final question to you is that what gaps still exist in protecting women in rural and underserved communities?
Yes, I think some of the gaps include housing. This is an issue all across Canada, urban and rural, but what we see here in Saskatchewan is sometimes survivors stay in situations longer than they would choose to because accessing housing is a significant barrier, whether they live on a First Nation, they live in a small town, or they live in an urban center. as well as that, I think sometimes there's barriers to reaching out for support. Sometimes it's geographic distance and transportation, supports for survivors, frontline professionals with expertise in intimate partner violence and coercive control. Yes, thank you.
Thank you, Mr. Chang. Mr. Fortin, over to you for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to all of the witnesses who have joined us today, and I will address my question to Mr. Champagne. I'm always happy to benefit from a professional for such an important bill. Mr. Champagne, I think I chatted with you for at least half a day on this topic, and a number of others. I'd like to address the issue of criminal harassment. C16 proposes to establish an objective standard rather than a subjective one. What is the fear that a reasonable person would have felt, or the fear objectively felt? We have witnesses who talk to us about this issue, notably the fact that if the victim of the harassment or threats truly fears, regardless of what a reasonable person would fear, that must constitute harassment. Should we really legislate on the sensitivity of each individual? I'd like to hear from you on that issue, please. Yes, I'll ask Mr. Marchand to answer your question, please. Thank you. I just found my mic. That's a very good question that you're raising. In the new wording proposed for harassment, there is still a certain form of mens rea required in the aggressor. We're very comfortable with the current wording, which says that the complainant or the victim must feel endangered because of the actions of the person in question, even if they don't feel that, if the person has the intention. I think that covers the topic. So I think that's why the mens rea of the criminal harassment is important. And the only reservation that we have is concerning insouciance. Recklessness, and that is what we think it's sufficient, and the Supreme Court recognized that there's a subjective mens rea, but for us, with the new definition, which, as you mentioned, is reasonable without this person feeling the fear. I think it's quite, I don't know if I'm answering your question, but it's quite broad. Yes, thank you, sir. I'll come back to an issue. Ms. Champagne, in her opening remarks, announced that you had some reservations about the way C16 proposes to work on the issue of reasonable court delays following the Jordan ruling by the Supreme Court. We have different ways of seeing this. C16 proposes a mechanism. I'd like to hear from you on that mechanism. Do we go far enough? Will we stamp out the issue for people who might be found guilty of serious offenses? And are we ensuring that they're not freed simply because they didn't have time to meet a reasonable delay? That's a big problem for victims and society in general. I'd like to hear from you on that, either Ms. Champagne. Well, I'll start. And then Mr. Marchand can jump in. The Bar Association is concerned when there are stays of proceedings, and we are aware of this problem. However, the Jordan ruling set out by the Supreme Court and also Cody recognize a fundamental right in our democracy to a right to be judged in a reasonable delay. So that's a balance that needs to be struck. And what we say is that we need to be careful about automatic rulings because that will not necessarily represent the situation. There's already a lot of details in Jordan that were set out in Cody. And what sets red flags for us, we don't want to have too many automatic procedures because those would be truly unreasonable. Mr. Marchand, I don't know if you want to jump in on this. Thank you. I see two issues. The government has tried a number of times to address the Supreme Court to try to change Jordan, and the justices didn't want to. So I think that we need to take that into account and to invest more resources into the system and also to try to have guidelines that are firmer for prosecutors so that cases that are not fit to be tried are not sent before the courts. A lot of our files should not end up before the courts. They go to court, and then files that are important, that are more important, see extended timelines. I think that's a real issue. Thank you.
Going to the second round, which is 5 minutes each. Given the time on the clock, I'm going to propose we shorten that to 4 minutes each. That way we'll get the full round in. No objections to that, except for Mr. Fortin, of course, he'll get his 2.5. Okay, so I see heads nodding. So Mr. Lawton, I'll give you 4 minutes, starting now.
Thank you very much, witnesses. Mr. Copeland, you had alluded in your earlier comments to Mr. Baber about some proposals for ways to beef up the mandatory minimums in Bill C-16, and you also cited other jurisdictions. If you could send that to the committee, I would greatly appreciate it, just as we review when we're amending this. I do want to talk to you about mandatory minimums, and this one tool that parliamentarians have that my Conservative colleagues and I have been very clear we think is needed on justice legislation, and that is the notwithstanding clause. Now, you have spoken and written about ways that this government is trying to basically neuter this power that all legislatures in this country have, and in doing so, defer a lot of discretion to the judges who have actually been the ones trying to weaken, in some cases, some of these protections. And I was just hoping you could speak to whether, in your view, the notwithstanding clause is a legitimate tool to ensure that mandatory minimum sentences, which reflect the will of large swaths of Canadians, can continue to have a place in the criminal justice system.
Yeah, thank you for the question. So I'll be happy to send some of those specific proposals. The United States is one jurisdiction, and there are numerous, objective criteria that one can establish to create a kind of gating situation wherein if these factors are met, plus the judge considers the punishment to be grossly disproportionate, cruel, and unusual punishment, then it could be levied. With respect to the notwithstanding clause, very clear that this is a part of the Charter, not something that is, some sort of exception to it. In fact, laws or constitutions are not straightforward. The text does not exhaustively define and prescribe all features of a right or how it's to be balanced with other rights or laws or policy objectives. And so it's very much a back and forth between the legislature and the courts in terms of how to interpret, define, and operationalize laws in ensuring their protection of the right in question and even operationalizing the right itself. And so it's very much a legitimate part of the law, and I think reflects our Westminster parliamentary system that gives great deference to Parliament for enacting laws.
Thank you. And just if I may, Mr. Copeland, as time is limited here, even before the mandatory minimums were struck down on child sexual exploitation and abuse material in the Senville decision, there was an analysis that the Investigative Journalism Bureau did that found, and they looked at 100 cases between 2020 and 2025, that 1 in 3 had not adhered to the sentencing minimum, and that was before it was struck down. So these are judges already finding ways to minimize and weaken these protections. What could be done to stop that and ensure that a minimum is actually being adhered to by judges in sentencing of these egregious sexual predators?
Yeah, it's a good point. There are many ways in which, at the level of prosecution or even police level, someone could bring forward a lesser charge, for example. Sometimes that's warranted. Sometimes it's, yes, to avoid, so to speak, the full effect of the law. And so things like, Crown Prosecution Manual amendments to make certain practices the default would be, an interesting way of addressing that. But I think, realistically, just returning to the use of the notwithstanding clause, it's no surprise we've seen its use increase, across the country in recent years. Is just because courts have been departing, in really serious ways from the clear intent of the legislatures in their creative rulings. And so I think it is entirely legitimate to be used in these settings. I do think that the bill makes some improvements here upon the status quo, but it could be strengthened further. And we'll have to see how the courts
Thank you, Mr.
use
Copeland.
and interpret the law.
Thank you, Mr. Copeland. Thank you, Mr. Lawton. Ms. Latanzio, you have 4 minutes.
Thank you, Mr. Chair. My first question will be addressed to Mr. Copeland. Mr. Copeland, you are absolutely right to raise concerns about the mandatory minimum penalties being struck down by the courts. That's precisely why Bill C-16 takes a smarter, durable approach. It reinstates those mandatory minimums with a judicial safety valve that reflects clear guidance from the courts to ensure charter compliance. Now, this isn't a partisan experiment. It is pragmatic. It is a solution that has earned the support across party lines. And I will remind my Member of Parliament Baber that his own colleague and Conservative colleague Frank Caputo has long advocated for the inclusion of the safety valve to ensure severe punishment of an offense is upheld. So the question to you, Mr. Copeland, is simple. If this model directly responds to judicial concerns, it strengthens the law and has cross-party support, what exactly is your objection to it?
Yeah, thank you. Great question. And so, like I said, I think it's a considerable improvement. I think we have to wait and see how the courts end up interpreting and using it. If they do, as they have been wont to do in many aspects of law, rely upon other factors to exempt, to basically operationalize the concept of cruel and unusual punishment, such as, referring to the race or, like I said, migrant status of the offender, then this would, because what the safety valve does is it narrows the application to just the facts at hand, but it still leaves all of the discretion with the judge. And there are many judges that are activist.
Thank you. I need to move on with the next panel. Merci, Maître Champagne et Maître Marchand d'être parmi nous.
Thank you, Ms. Champagne and Mr. Marchand, for joining us this afternoon. I'd like to ask a question concerning the balance struck between strengthening protections of victims with Bill C-16 on the one hand, particularly in the context of spousal violence, intimate partner violence, and also respecting the principles of criminal law and constitutional protections. What do you think? Answer. As I said at the outset, we salute the objectives sought by C-16. However, we see that there are components that are concerning and that could be improved upon. For example, the three separate offenses between harassment, coercive control, and femicide. We salute the objectives, but the devil is in the details, as they say. So that's why we have comments to make, and we think that the Bill C-16, could be improved by taking our comments into account. Mr. Chair, if I still have time, I'd like to focus on mandatory minimums with either Ms. Champagne or Mr. Marchand. In your opinion, what do you think about this approach? Do you think it reconciles the objectives of punishment and dissuasion with constitutional requirements? I'll give the floor to Mr. Marchand.
Your mute button is on, sir. Mr. Marchand, your mute button is on.
OK, je m'excuse.
Oh, sorry. Our perspective is that the new section on mandatory minimums wipes out everything the Supreme Court has said since the very beginning, and it's nearly the adoption of a notwithstanding clause, a Section 33. The first case that is tried under this will certainly go to the Supreme Court. Can Parliament rewrite Section 12 of the Charter? That's the question, and I think that Parliament could have responded differently by redefining aggravating circumstances, by making it more clear when mandatory minimums apply. Now they're simply saying it's cruel and unusual, and these are collective actions. In the case of class actions, it allows the Supreme Court to make a ruling that will be binding for everyone, and now it needs to go case by case, and we're talking about unloading the legal system. That won't be what happens. It will have to be done case by case, and that really goes against the current. So we are very firmly opposed to this section as proposed, and furthermore, the mandatory minimum will be a mandatory minimum imprisonment. So in all cases, there will be more. There's no possibility of an absolution. So.
Thank you, Ms. Latanzio. Okay, Mr. Champoux for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'm going to turn to you quickly, Ms. Champagne, since you responded to Madame Latanzio and you talked about the details and the fact that the devil is in the details. And I know that in law, the details cannot be left to chance. And in terms of femicide and C-16, I think it's very important to have this conversation. Do you think that in the current state, the term or notion of femicide in criminal law is well defined and well set out? And is it possible to navigate it effectively? Answer: no, there is no definition of femicide. So for us, the objective is not achieved. So what we would propose would be to have, if it's the legislator's intent, there needs to be a definition that gives very clear guidelines to femicide. And we think that currently it's much too broad and could include a homicide against a man. I'll follow up on your answer. I'm going to jump and ask you if you have the same opinion about coercive control. Has the definition been specific enough? Answer: what we see is that the three offenses stem from the same behaviors, and the suggestion that we are making to parliamentarians is really to strengthen harassment, to include coercion, perhaps with aggravating factors, and to set femicide on its own to distinguish the behaviors and their seriousness. So for us, that would be much clearer for Canadians to understand what a criminal offense is, since the three offenses for the moment are sort of interconnected, and it's hard to understand what is intended for each of the offenses. Thank you very much.
Okay, we've got Mr. Gill and Mr. Housefather. I might cut it down to 3 minutes each, if that's all right, just because we're up against the clock here. Mr. Gill, to you, sir.
Yeah. So my question to Mr. Copeland. Mr. Copeland, Peel Region Council declared intimate partner violence an epidemic. Peel Police responded to 46 intimate partner violence calls per day. That's one every 30 minutes. What got us here?
Well, I think it's a long-standing issue, and the government is right to address it with stronger offenses for coercive control and various types of sexual violence. I think my comments and concerns pertain to how the offenses are structured, and there is precedent here as other jurisdictions have moved to implement coercive control regimes. And the one that has not resulted in a lot of success in England is very close to how this offense is worded. All of the different components are standalone, and they're very imprecisely defined. So you can have a situation wherein people are bringing forward cases that are not legitimate, that in fact they won't stand charter tests, and we've seen this in England. Whereas the predicate model, wherein multiple offenses have to be strung together and over a defined period of time, it's a much more concrete and easily prosecutable offense, and it has resulted in much more success. So I think the definition needs to be tightened in line with that.
So if liberal bail and sentencing law got us here, should we trust them to get us out of this crisis?
Well, I think, yes, it's certainly the case that the lenient bail and sentencing policy has been behind some of the decades-long rise in violent crime, and intimate partner violence is certainly a component of that. I do, like I say, appreciate the intent here, but to have the desired effect, the offenses need to be seriously amended.
A couple of months ago, you told this committee that one of our biggest issues is repeat violent offenders and the expanding reach of organized crime, and that we need to reduce excessive judicial discretion. Can you elaborate on that in the context of C-16?
You have about 10 seconds,
I
Mr.
do.
Copeland.
As I said in my last response, I think the minimum penalty amendments go some degree in that direction, but there are additional amendments that can be made to
Thank you, Mr. Copeland.
properly constrain it further.
Okay, Mr. Housefather, I'll give you 3 minutes, but I don't think anybody will be upset if you don't use it all. So over to you.
Merci, Monsieur le Président, et merci à tous les témoins.
Thank you, Mr. Chair, and thank you to the witnesses.
This round of the show. So I have a couple questions for you also. I mean, I think we're all very concerned about Jordan, and the effects of Jordan, which is where Ms. Latanzio talked about the safety valve that you opined on a little bit earlier. But I also wanted to ask you about the fact that I believe that this bill also offers other remedies other than stay of proceedings, which will, I think, prevent the 10,000 case number that you talked about. Do you want to talk about the other remedies that are also afforded under the bill besides the safety valve?
So who's the question directed to?
It was directed to Mr. Copeland. I thought I had made that clear.
Oh, sorry. Could you repeat that? I'm sorry.
Oh, okay.
Just the last part.
Yeah, no, what
pertaining to Jordan.
What I had said is that, we're all concerned about Jordan. Ms. Latanzio had raised the safety valve issue, but what I also pointed out is that there's now other options than stay of proceedings that are being afforded under the bill. Could you talk to how that will impact the number that you raised of 10,000? I mean, this will mean that fewer cases will be thrown out.
Yeah, exactly. No, I commend the government for these measures here. Largely supportive of what's in here. As others raised, there are many factors, and I support additional resourcing for prosecution and for police as well, because that's certainly part of the equation. I do think that special note could be made of national security and organized crime as circumstances that warrant that extra discretion. I think that would just underline that point, as these are the cases that are driving our everyday violent crime issues. A lot of it is driven by organized crime, and there is frequently a foreign state involvement component, so national security. So I think that would just ensure that those cases are not tossed.
Understood. Just really rapidly, I think my Conservative colleagues may have tried to trap you into an answer on the notwithstanding clause before, so let me just give you the opportunity to opine on this. The federal parliament has never used the notwithstanding clause. You're not recalling on the federal parliament to use the notwithstanding clause here, right? You had talked about the dialogue between courts and the parliament and legislatures, and the issue with the notwithstanding clause has not been the notwithstanding clause's inclusion in the charter. It's been preemptive use that prevents the dialogue between the courts and the legislature. So are you actually asking the legislature here for the very first time in Canadian history to use the notwithstanding clause in this bill?
I think that the preemptive use is very much a part of the dialogue, in fact, because it states clearly that this is the legislature's interpretation.
But then there's no dialogue.
But let me just finish.
Don't say it's a dialogue between the courts and the legislature if you're saying that there shouldn't be a dialogue. I asked you, are you asking for the notwithstanding clause to be used on this bill?
Thank you, Mr. Housefather.
Well,
Mr. Copeland, do you want to answer
that? Sure, yeah. I mean, it is part of the dialogue because there's a 5-year limit to it. What I'm saying is I think this is a good measure. I think there are ways that it could be improved further. I would not rule out its use if courts do not respond appropriately to the bill, the law being put forward here.
Thank you, Mr. Housefather. Mr. Copeland, I have one quick question. Are you a lawyer?
No, I'm not.
Thank you. Okay. Just to wrap up quickly, I know Mr. Brock wants to add something. We're going to complete the witness portion of this bill on the 22nd. We're going to start clause by clause on the 27th. So proposed amendments rather, should be submitted by noon on Thursday, April 23rd. So everybody has that in their mind. Mr. Brock, you had a question for me?
You've answered all my questions. I wanted clarification on those two issues.
Well, we'll end on the note that great minds think alike, Mr. Brake. Okay, meeting adjourned.